and welcome to 3PB's case recording for January 2021. I'm joined by Grace Nicholls. My name is Karen Moss, and we're going to be dealing with two cases that were in the EAT and the High Court, respectively, in December 2020. I'm going to be dealing with Quilter, Private Client Advisors, and Fulcrum and Continuum Financial Services, LLP, which was in the Queen's Bench division before Mr. Justice Calver. And Grace is going to be dealing with Steer and Stormshaw Limited, which was in the EAT.
And what was the case of Faulkner about?
Well, Ms. Faulkner was a regulated financial advisor. She specialised in high net worth individuals and business owners. She started to work for the applicant in this case, who was Quilter Private Client Advisors, in January of 2019. And in short, she didn't like it. She was only there for 6 months. She resigned with 2 weeks' notice because she was within her probationary period. She was unhappy really with three things. First of all, she said the level of administrative support was insufficient. She was also unhappy that there were restrictions on the products that she could recommend to her clients. And thirdly, it was found that she wasn't getting on with her manager. Shortly after her resignation, she began working for a competitor of Quilter, Continuum. So that was the co-defendant in this case. Her contract of employment had a number of post-employment restrictions, and I'm going to read the three most relevant words in relation to those three covenants. The first was a non-compete clause, a non-competition covenant, and that is for 9 months following termination and in competition with the company. She was prevented from being employed or engaged in, assisted or interested in any undertaking which provides the similar services to Quilter. The second clause was a non-solicitation clause, and that prevented her for 12 months following termination and in competition with the company, soliciting or otherwise endeavouring to entice away from the company the business or custom of any customer in relation to the supply of services. And then finally, there was a non-dealing covenant as well. For 12 months following termination and in competition with the company, she was prevented from being concerned with the supply of certain services to any customer. Now, the contract did define customer as any person, firm, company or entity in respect of which terms and conditions of business for the provision of financial advisory services have been in place between that person, firm, company or entity and the company during the 18-month period prior to termination, and in respect of which the employee was materially concerned or had material personal contact at any time during such 18-month period prior to termination. And then also services was defined in the contract as meaning those parts of the business of the company with which the employee was materially concerned at the time during the 12 months prior to termination. So those were the particular clauses, and in fact what happened just before she left, Miss Faulkner scanned naughtily a substantial amount of Quilter's client documentation onto her personal laptop just before she trotted off to their competitor. Although Quilter knew within a week or two that she had gone to Continuum, they waited a 4.5-month period before they applied for injunctive relief. I don't know about you, but I have experience of people just waiting far too long to apply for injunctive relief, and I think this is probably normally because they're nervous about the costs and they might as well just wait and see what happens. But in this case, that wasn't a good decision. But anyway, the witnesses for Quilter conceded that they weren't too concerned about the fact that Miss Falconer was working for a competitor, but they were concerned about solicitation, which explained some of the delay. And she claimed, just like so many claimants claim, constructive dismissal in defence of the application for an injunction. In very broad terms, it came before Mr. Justice Calver in the Queen's Bench Division, and as what he decided is that the 9-month non-compete covenant was an illegal restraint of trade and therefore void.
And Karen, why was the non-compete clause not upheld?
Well, for a number of reasons. Mr. Justice Calver did find that Miss Falconer had breached her contract. She breached the terms of fidelity and confidentiality. He also found that the legitimate business interests cited by Quilter were requiring of protection, that is a special trade connection and business secrets, but Mr. Justice Calver found that the covenants were too wide and reasonably necessary for the protection of those interests, and so did not uphold the non-compete clause. He gave 10 pointers, I think, in his judgment. And in my view, these 10 points will be really helpful to practitioners. Most of them will be familiar, but it's a kind of useful checklist, particularly when considering what evidence to tell the clients to look for or adduce in their witness statements attached to any application for injunctive relief. So number one was that Quilter had failed to adduce much evidence at all about the necessity of the non-compete clauses, and that was an error. And sometimes it can be quite difficult. You really need to consider why a particular clause or particular restriction is necessary. Secondly, Miss Falconer in this case was able to go lawfully, she was able to terminate her contract lawfully with only a 2-week notice period because she was within her probationary period. And what that suggested was that she was less important to the company than those with much higher, much longer notice periods. And in turn, that meant that the perceived need for protection was diminished. Thirdly, the length of restriction was the same during the probationary period, even though Ms. Falconer would obviously have only had 6 months or up to 6 months to build any kind of relationship. And the evidence that was adduced, essentially by both sides, suggested that such a relationship would take about a year to build. So why does Quilter need protection where, theoretically anyway, nobody in their probationary period would have been able to really build up a relationship that was worth protecting? Fourthly, and this is kind of related really to the first one, there was no or very little evidence about why Quilter needed a restriction for as long as 9 months. Again, it just there just wasn't much evidence in relation to that. Fifthly, and interestingly, employees more senior to Miss Falconer with Quilter had the same or less onerous restrictions than she did. And again, there's an implication there that the restrictions for more junior employees like Miss Falconer were wider than reasonably necessary. Sixthly, it was found that Quilter's legitimate business interests would have been adequately protected by a non-dealing clause that was appropriately worded, just so that that could cover the Quilter's own customers and didn't go any wider than that. The non-compete clause would have prevented Miss Falconer from working with new clients that had nothing to do with Quilter, and therefore it was wider than reasonably necessary. There is also usually an argument, I've run it many times, that non-dealing covenants are difficult to enforce, and that's why you need a non-compete clause. But in this case, again, there was just no evidence about why it was difficult to enforce a non-dealing clause. Normally, it is said that it's difficult to identify clients with whom the defendant has had contact during their employment, and therefore they're difficult to enforce. In this particular case, Ms. Faulkner's case, it was easy to identify clients that she dealt with during her employment with Quilter. So the judge found that, well, that excuse really wasn't open to Quilter. There was a carve-out, a geographical carve-out, but Quilter was a nationwide business. So although the carve-out looks like it restricts or limits the effect of the restriction on Miss Quilter, in fact, it really didn't have any practical effect at all. 8, there was no evidence of an industry standard in this case. Again, some industries do have standards in relation to non-compete clauses, and if there was such a standard in this sector, there was no evidence of it. Ninthly, as I said before, the witnesses for Quilter said that they were not too concerned about the fact that she had gone to work for a competitor, but they were concerned about solicitation. That really, I think, meant that the court was bound to find that the non-compete clause was wider than necessary, because even Quilter's witnesses suggested that it was. And then finally, there was a significant delay here, 4.5 months after the breach occurred. The judge was left thinking, why did Quilter wait so long to apply?
Was there anything else about the judgment you found particularly interesting?
There was, Grace. I'm glad you asked. There was the public interest in this case became interesting because Quilter had a regulatory obligation to act in the best interests of its clients. What was argued for Ms. Faulkner is that the non-competition or non-dealing clauses acted as a fetter on the client's ability to instruct the advisor of their choice. And what was argued is that that because it wasn't in the client's best interests, it was arguably a breach of Quilter's regulatory obligations to enforce these covenants against Ms. Faulkner. The extent that there was conflict between a firm seeking to enforce one of these covenants and the interests of the client, that conflict must be resolved in favour of the client, it was argued. Well, Mr. Justice Calver wasn't entirely convinced by that argument in relation to public interest, but he did say the following. I'm going to read out part of his judgment. He says, it was necessary to balance the public interest in the protection of the goodwill in terms of customer connections and the trade secrets of businesses of this type against the public policy that financial services advisors should be free to act in the best interests of the client by, in particular, being able to join a competitor who offers the client a market-wide offering of financial products rather than being forced to remain at a current employer who only offers those clients a restricted in-house offering of financial products. But if the restrictions are found to be reasonable as between the parties by reference to the first of these considerations, then it is likely, in my judgment, that it will outweigh the latter consideration. After all, the client can always choose to engage a different financial services provider who does offer a full market service regardless of the position of the individual financial advisor. So there was no full argument on that point because Mr. Justice Calver left the point open. It's still an argument that I think can be put in an appropriate case. And of course, it goes way beyond regulated services, certainly financial services. It could be applicable in many, many cases where there's arguably a conflict between a firm wanting to enforce a covenant and the client's best interests. So that is an argument that may well be put again in the future, I think.
And what about the other restrictive covenants you mentioned? So the non-solicitation and the non-dealing clauses, what happened to those?
Well, they weren't upheld either, but for more straightforward reasons, really. There was, if you'll remember, when I read out the definition of customer, it included an 18-month backstop. That is, so for customers that Miss Falconer had dealt with for the last 18 months. She was only employed for 6 months, but backstop was 18 months. And Mr. Justice Calver simply found that was too wide. What he considered, which seems to me to be reasonable, was that any customer connection that was under threat at the point 18 months before termination had essentially probably gone stale by the time the defendant would be leaving her employment.
And you said in your article in the newsletter there was an interesting point about affirmation. I wonder if you can briefly take us through that.
Yes. So as I said at the beginning, Miss Falconer argued that she had been constructively dismissed. So she said that was one of the reasons why the restrictive covenants couldn't be enforced. And in fact, the High Court found that she hadn't been constructively dismissed because there wasn't a repudiatory breach. But the point about affirmation was interesting because in the civil court jurisdiction rather than the employment tribunal jurisdiction, in order to prove a constructive dismissal, one is normally expected to resign without notice. Employment lawyers will know that it doesn't matter whether you resign with notice or without notice for the purposes of constructive unfair dismissal case under Section 95 of the Employment Rights Act. But in a wrongful dismissal case, it does make a difference, and essentially you must resign without notice if you don't want to risk having or being considered as having affirmed the contract. And that's the principle that was cited and considered by Mr. Justice Calver from Cochrane and Air Products PLC, which is back in 2014. What was interesting is that Mr. Justice Calver stated that he would not, so if there had been a repudiatory breach, he would not have found that the 2-week notice period meant that Ms. Falconer had affirmed her contract. And what he said, I'm going to quote again, if I may, from the judgment, he said, "It is undoubtedly the case that if the employee decides to accept the repudiatory breach, he must do so unambiguously and with sufficient dispatch. If his purported acceptance is delayed, he runs the risk of a court finding that his action has not been sufficient to discharge the contract. However, in my judgment, it is what happens during the delay which is the critical feature. Provided the employee makes unambiguously clear his objection to what has been done by the employer, he is not necessarily taken to have affirmed the contract by giving a short period of notice and continuing to work and draw pay for a limited period of time. To this extent, I would respectfully disagree with the observation of Mr. Justice Simler that at common law, an employee wishing to resign and successfully claim constructive dismissal would necessarily have to resign without notice." That's the reference to Cochrane. It all depends upon the facts of the particular case, whether the employee has nonetheless unambiguously accepted the repudiation of the employer and with sufficient dispatch. The length and circumstances of the delay require to be examined in each case. So that is interesting because previously it was thought that any period of notice meant that the contract had been affirmed, whereas that has been at least questioned by Mr. Justice Calver in this case. Coulter and Falconer is an interesting one. It's another good example of I think, a well-reasoned judgment, which I think will help practitioners when dealing with either drafting the restrictive covenants in the first place and also preparing or defending an application for an interim injunction. Coulter and Falconer really provides a good reminder for practitioners to adduce evidence that the covenants that are included in their contracts are reasonably necessary for the protection of their legitimate business interests. Grace, you're going to talk to us about Steer and Stormshaw Limited in the Employment Appeal Tribunal.
I am. Thanks for that summary, Karen. That was really interesting. So Steer and Stormshaw is a case involving an individual who was employed by the respondent from the 12th of March 2020 until the 15th of July, so a mere matter of months. And the claimant in this case contended that she was subjected to sexual harassment consisting of inappropriate conduct related to her sex from a fellow employee. And she said that the respondent had failed adequately to protect her from such harassment. In June, so a few months into her employment, she presented a grievance, which she contended was not adequately investigated by the respondent. As she also requested to work from home, which she said was a protection to safeguard herself from unwanted harassment. She eventually was permitted to work from home, but once at home, she was instructed by her employer to install something called screenshot monitoring software, which she said was effectively an attack on her integrity. And as the judgment sets out, an unjustified intrusion into her private life. The claimant alleged that she was notified in mid-July that her working hours be reduced to some 60% with effect from the week after, and apparently because of childcare responsibilities. Now, the claimant said that such a unilateral change amounted to an express dismissal, and in the alternative, she said that she'd been constructively dismissed. She contended that her dismissal had amounted to sex discrimination and victimisation, and essentially also she pleaded her case in the alternative that she'd been dismissed as making a protected disclosure and therefore had been automatically unfairly dismissed, contrary to Section 103A of the Employment Rights Act. The claimant presented claims on the 30th of July of last year and sought interim relief, both in relation to her whistleblowing claims and her sex discrimination and victimisation claims.
And what did the Employment Tribunal say in relation to interim relief?
So before it even got to a hearing, the tribunal wrote to the claimant and listed an interim relief hearing only in respect of her whistleblowing claims. And when the claimant sought reconsideration of the decision to list for whistleblowing only, the tribunal wrote back to the claimant and said it didn't have jurisdiction to grant interim relief in relation to discrimination matters. In advance of the interim relief hearing, the claimant decided to appeal the decision to the EAT. And of course, the Employment Tribunal hadn't heard full argument at this point. And there was some contention within the judgment about whether this had been the appropriate step, because of course, one would assume that a decision on appeal should be a fully reasoned decision from the tribunal. But Mr. Justice Kavanagh in the EAT remarked that it was appropriate to grant permission, given that the appeal was concerned with such a specific and pure point of law, and clearly of quite significant public importance.
So what did the claimant argue before the Employment Appeal Tribunal?
So it's right to say the claimant accepted on the face of it that there was no such right for interim relief under the Equality Act 2010. And it's also right to say that the claimant had the support of the Equality and Human Rights Commission when she was before the EAT. The claimant sought to read in a right to the Equality Act and essentially that the right for interim relief was required by law or by the European Convention on Human Rights. And there were three principles of EU law that were relied upon by the claimant, namely the principle of effectiveness, the principle of equivalence, and generically fundamental principles of EU law.
And what about the intervention from the ECHR?
There was more success on this argument. So the argument being advanced here was that the failure to grant a right to claim interim relief in dismissals rooted in discrimination and victimisation had infringed Article 14 of the ECHR. The EAT found that Article 14, namely the protection from discrimination, was engaged because of the interplay with Article 6, which of course is the right to a fair trial. The EAT considered that difference in treatment in Section 103A claims and discrimination cases hadn't been justified and that no legitimate aim had been advanced. It's right to say that the respondent, so the claimant's former employer, was present before the EAT, but quite fairly said or could not explain why difference in treatment existed. It was a private company. Permission when permission had been given to appeal to the EAT, it's right to say that apparently the government legal department had been written to, been notified about the appeal, and had been given the opportunity to be represented or provide written submissions to the hearing, but it had not done so. As I understand from the judgment, there had been some communication, but for whatever reason, no written submissions were provided, and counsel wasn't there representing the GLD at the EAT.
So what did the EAT determine?
Mr. Justice Kavanagh said it would be inappropriate for him to speculate about whether, and if so, why there was a difference in treatment, and whether that was a proportionate means of achieving a legitimate aim, because the burden was on the employer to justify the difference, and it was unable to do so. And by that, of course, I mean Stormshaw. And in fairness, that was through no fault of their own. The EAT concluded that there had been a breach of Article 14 of the ECHR, but the EAT was in some difficulty because it had no power to make the requisite declaration of incompatibility. And it would be wrong, again, for the EAT to adopt a conforming interpretation of the Equality Act to enable it to read in a right to apply for interim relief. No relief for the breach was able to be granted by the EAT, so Mr. Justice Kavanagh gave leave to appeal to the Court of Appeal so that the Court of Appeal could consider whether to grant a declaration of incompatibility for breach of Article 14. It will be really interesting to see where this case up and if and when it reaches the Court of Appeal. And as was noted by Mr. Justice Kavanagh in his decision, it was a surprising feature of the challenge that there had been no similar challenge previously brought, given that the Equality Act has been in force for over 10 years now. So that was the case of Steer and Stormshaw. Thank you very much to Karen for her roundup of her case as well. And thank you all for watching. And please look out for future editions of our newsletter, webinars and podcasts from the Employment Group. Thanks.